Welcome to the Rozanne On Demand CFPB video series, featuring Ontario System's Chief Compliance Officer, Rozanne Anderson. Widely recognized as a leading authority on collection-related compliance, Rozanne leads Ontario System's corporate efforts in response to the CFPB's launch of compliance examinations in the arm industry. In this ongoing video series, Rozanne takes a deeper dive into the entire regulation, helping you make sense of the new rule and what it means for your agency. Before we get started, please take a moment to review our legal disclaimer. The information shared today is not legal advice. Please consult with your own independent legal counsel before making any business decisions regarding the use of this information.
Welcome to today's video podcast addressing Regulation F, the new rule for debt collection. Today our focus will be on 1006.30 of the new rule, described as other prohibited practices. Last time we spent a fair amount of time talking about unfair or unconscionable means of collection. This particular section, .30, focuses on other practices that are basically frowned upon by the CFPB. And we must have riled the CFPB in some way, shape, or form, because the first prohibited practice actually is clarification that a debt collector cannot sell, transfer for money or any other form of consideration, or even place for collection if the debt collector knows or should know that the debt has already been paid or settled or discharged in bankruptcy. That is a new provision. It is not found in the Fair Debt Collection Practices Act, and the purpose of it is to make clear that there is a new expectation on debt collectors that they do not basically reintroduce debts into the stream of commerce when they know or should know the debt has been paid, settled, or discharged in bankruptcy. Now, there are some exceptions to that general rule. Obviously, if you're returning the account to the creditor, that's not deemed to be a transfer in exchange for consideration that trips this prohibition. Another example of a prohibited transfer would be secured claims in bankruptcy. A debt collector under Regulation F may sell, transfer for consideration, or place for collection a debt that has been discharged in bankruptcy if the debt is secured by an enforceable lien and the debt collector actually notifies the transferee that the consumer's personal liability for the debt was discharged in bankruptcy. This is a concept that probably falls outside the scope of this podcast, but what they are getting at is the fact that there is oftentimes a difference between the actual personal obligation of a person to pay, a promise to pay, and the actual security interest in that particular asset. In other words, the money that was used to purchase a particular asset. What the CFPB is explaining in this provision, that you can sell the debt that's been discharged in bankruptcy only if it was secured by an enforceable lien, and you let the party to whom you are transferring the debt that the personal liability of the consumer was discharged, so you're not going after the consumer. The CFPB in 1006.30 has also revealed its concern over consumer payments on multiple debts. What they state in this section of the regulation is that if a consumer makes any single payment to a debt collector with respect to multiple debts owed by the consumer to the debt collector must not apply the payment to any debt that is disputed by the consumer, and if applicable, must apply the payment in accordance with the consumer's directions. So let's think about this just a bit. If the debt collector presents a debt on a consumer portal and does not disclose that that debt is disputed to the consumer, the question is going to be, will the CFPB consider that deceptive in any way, and that the debt is presented to the consumer as one of multiple debts to be paid, but the debt collector does not disclose that the consumer has already disputed that debt? It is our position that a configurable safeguard for the debt collector will be to have a way or a means to disclose to the consumer that a particular debt, which is part of a series of multiple debts, is disputed, so that the consumer can make an intelligent, informed decision when making a payment toward multiple debts. And that you know that when you receive that single payment, absent any other indication from the consumer, that you will not be applying the payment to the disputed debt in that multiple debt series. Continuing with this list of other prohibitions under 1006.30, let's take a look at the CFPB's view on legal actions by debt collectors. First of all, they address actions to enforce any sort of an interest in real property. Now, I know that many, if not the majority of debt collectors, are not collecting debt that is even secured debt, much less secured by any sort of an interest in real property. But if you are one of those debt collectors, be aware that a debt collector who brings a legal action against a consumer to enforce an interest in real property that secures the consumer's debt, they must bring the action only in a judicial district or similar legal entity in which the real property is actually located. So we're talking about venue, we're talking about where you need to exercise any of your rights to enforce an interest in real property, whether it's garnishment, whether it's the actual litigation, any sort of foreclosure action. I mean, you name it. When it is involved, when it's a legal action, and it's initiated by a debt collector in connection with the collection of a debt. Remember, debt collectors includes attorneys who are collecting a debt. That means that they must be mindful of the fact that the actions must take place in the judicial district or legal entity where the property is located. Other legal actions, probably this is more relevant to a broader group of debt collectors, but a debt collector who brings a legal action against a consumer other than to enforce an interest in real property securing the consumer's debt. So we're not talking about what we just talked about with real property and with a debt enforced by a security interest in real property. Now we're talking about one that's not secured with an interest in real property. The debt collector must bring that action in one of two places. Either the district or legal entity where the consumer actually signed the contract that's being sued upon, or where the consumer resides at the commencement of the action. Two very important venue provisions, and they are different from the provision addressing where you will file a lawsuit or exercise any legal action when the debt is actually secured by real property. As if to predict that debt collectors may interpret the previous two provisions about venue as an authorization for a lay debt collector to basically function as an attorney. In paragraph 3 of 1006.30, the CFPB makes clear that nothing in this part authorizes debt collectors to bring legal actions. In other words, if you are a lawyer, would be graduating law school, passing the bar, becoming licensed, maintaining a license, etc., in the proper jurisdiction. That is what authorizes a lawyer to bring a legal action. The FDCPA and Regulation F is not grounds to determine whether you can bring a legal action. So they have cleared up any doubt about that risk. This brings us to the conclusion of our discussion of 1006.30, other prohibited practices. Next time, we will focus our attention on disputes and requests for original creditor information. Thank you.
Thanks again for tuning into this week's episode of the Rozanne On Demand CFPB video series. As always, be sure to visit the Ontario Systems website for more exclusive events and information regarding the 2021 CFPB new rules.